Good evening. My name is Paula Silverman, and I am on the board at HopeWell, and I get the honor and pleasure of introducing our speaker today. Jane is here to talk to us about estate planning, debunking some of the myths, and I think it's going to be a very informative discussion. And I think too is like, do you want to hold questions until the end or as we're going along? Okay. And just to let you know too that Jane is a breast cancer survivor, so she has that set of eyes that are bringing to today's discussion. So I'm glad that you're here, and thank you for joining us.
My name is Jane Sims, and I'm an estate planning attorney. And I talk about estate planning all day. And no one ever says to me, "Oh, Jane, that was so fun." Like, it was really exciting. We talked about death and taxes, and I loved it. So I try to make this as enjoyable as possible. And that's why I try to teach estate planning through like mistakes. It's much more interesting to hear about like the mistakes you don't want to make rather than just like, this is a will and this is what a will does. So that's why I structured it like this. We are going to go through 10 misconceptions. And I do not expect you to be able to read this. It's too small to read on this screen. So we do have like printouts in the back if you want to look on. But we're going to go through each of these misconceptions in separate slides. But just so you see them all together, here is the outline of what we're going to talk about. These are the misconceptions. A lot of people think all my assets are going to follow my will. Whatever my will says, that's where everything goes. And that's a misconception. People don't think about the beneficiary designations on their retirement accounts or their life insurance. Those are super important, and we'll talk about why. I often have clients who say, well, can't I just add my son to my bank account or the deed to my house? Won't that solve everything? That will actually create a lot of problems. So we'll talk about that. Other people think, well, I'm not a millionaire. I don't need to worry about estate planning. But estate planning is not just about saving money. It's about your wishes. It's about making sure your family gets along, long term in the future. We'll talk about estate tax because Maryland has an estate tax that's fairly onerous compared to other states. And a lot of people think, oh, well, life insurance and retirement accounts, those are tax-free, right? No, they are subject to estate tax. So we'll talk about that. We will also talk a little about income tax. It doesn't matter. I know like a lot of us in this room are, 25 years old and we think we're way too young to worry about this stuff, but it's important for young people as well as older people. I often get people who come in and say to me, I downloaded a will off the internet. Like, it's fine. Why do I need to pay a lawyer? So we will talk about that. You might have heard of revocable living trusts. There are a lot of myths and misconceptions surrounding those trusts, so we will go over that. And then I want to end by talking about charitable giving, because there are so many great ways to give to charity. You don't have to have $20 million to give to charity upon death in a tax-efficient way. So we'll talk about that as well. Okay, so let's start by debunking the first myth. All of my assets will be distributed based on the terms of my will. That is not true because titles trump wills. If your home, for example, your house, for a lot of people, your house represents most of your wealth. If you title your house jointly, with your second wife, and your will says, I give everything to my children from my first marriage, you're giving your assets to your second wife because your will never come into play. The house will pass according to the joint title with your second wife. So titles are more important than wills. I always tell people I can draft you the nicest will, the nicest document, But if you have the wrong person on title with you or the wrong beneficiary, the will's not going to work. So these are really important things to remember. Beneficiary designations, second most important thing to remember. A lot of people say, I didn't fill out my beneficiary designation form because I have a will and everything will just pass according to my will. Well, that's not necessarily tax efficient. First of all, you have to remember, who it is that you appoint. A lot of people forget who they appointed. If they do fill out the form, they might have their ex-wife on there or their ex-husband, and they just never updated it. And I have been involved in court cases where, the new wife is trying to get access to the life insurance or the retirement account proceeds, even though the ex-wife was still on there, and we cannot get those assets back. We always lose. Sometimes with like a government sponsored plan, you might win, but it's difficult. So it's really important that you update those beneficiary designations regularly. Yep. So mutual funds or stocks, you can have a beneficiary on. It's not necessary for tax purposes, but it is one way to avoid the probate process. And we'll go through what the probate process is and why it's helpful to avoid it. But for a retirement account, like a pre-tax money, you definitely want a beneficiary because you want that beneficiary to be able to roll over into their own account and then take the tax distributions over a period of time versus having it go to your estate and all the taxes due very quickly. With a mutual fund, there isn't a risk of having, it pass through your estate. It's not a tax risk. It's like a probate. Do you want to avoid probate? So that's why certain designations have adverse tax consequences. But let me just, I don't want to steamroll over your point. One thing that is also important when it comes to why not have a beneficiary on your, let's say, just your regular mutual fund account. That works. Let's say you have your daughter on the account as the beneficiary. That's fine as long as you're okay with your daughter receiving that money outright at death. Like if your daughter's going through a divorce or has creditors or is super wealthy on her own, you might not want her to be the beneficiary. You might want it to stay like in a longer term trust. So that's what came to mind. Yes.
Well, my one brother is older. What if he passes before and then I pass? Go on there. What happens with him as a beneficiary?
If he dies before you? Yeah, so if he dies before you, you want to see if you can add a contingent beneficiary, or if the beneficiary designation form has the ability to say like have survivorship, like so he's only a beneficiary if he survives you. Beneficiary designations can be a little limiting because sometimes they don't let you like have all those permutations that you'd have in a will or a trust. So you should definitely check with the institution where you have the money and make sure that they have the ability where you can say, okay, if my one brother's not living, it'll go to my other brother. Yeah, yeah. It's really about how property transfers. Property transfers by title, joint title. There are even like deeds where you could have a life estate and then the remainder goes to a beneficiary. That's title. But it passes by beneficiary designation. If you don't have a joint owner and there's no beneficiary designated, that's when your assets will go through your will. And your will go through the probate process that we'll get to. You can also have assets that pass by trust, and we'll talk through trusts. And then you can gift assets during your lifetime. And there's sometimes it makes good sense. You help, children or family members in need through gifts, and it can have an estate tax benefit as well. So people ask me all the time, can I just add my son to my bank account? Can I just add my son as a joint owner to my house? And there are a lot of risks to that. I don't like doing that, and I caution my clients against it. The first reason is, let's say your son helps you with everything. You have 3 kids, but your son, is the best. And you want him to be the joint owner of your bank account so that he can write checks for you and help you out once you can no longer do so yourself. The problem is if you have, $100,000 in that account, and that's a big portion of your assets, a joint owner will inherit that account. So that account will not end up with your other children. It will all go to the one son, and then he doesn't have to share it with the siblings. And people often say, well, of course he will. That doesn't happen, like, at least half the time in my experience. So you can have the same benefit by using a power of attorney, and we'll talk about powers of attorney. There's also a liability risk. So if you, add your son to your house, so your son's a joint owner of your house, and you think this is great, when I die, he'll already own a house, and I've made this so much more efficient. Well, what if your son gets in a car accident? Or what if your son gets divorced? Suddenly your house, which actually is owned by your son too, is subject to a division upon divorce, or subject to a lawsuit creditor suing your son and getting your house. So I really caution people against adding a joint owner to your house unless, it's your spouse. Also, when you add someone's name to an account or a deed, you're actually making a gift to them. And that if you're supposed to file a gift tax return with the IRS when you do that. A gift has the same basis that you had, so your property won't necessarily get a step up in basis upon death, so it creates income tax problems. And what I found is when you're buying a house, like the title attorneys, they just they don't think in estate planning terms. So they'll add whoever you want to title, but you want to think twice about it. It's a really important decision. Then some people think they don't need a will or a trust or any estate planning because, I'm not a millionaire. I don't need all this, work. I don't need to spend time focusing on it, but you really do. First of all, Maryland, you don't have to be a mega millionaire to have tax in Maryland. Maryland has a tax exemption of only $5 million. And you say, well, I don't have $5 million in the bank. It doesn't need to be in the bank. A lot of things go into that $5 million bucket. So let's say, you have $1 million life insurance policy. It's just a term policy. So you're not thinking that it's something super valuable, but that falls into your $5 million bucket and starts filling it up. Your IRA and your 401k also are subject to estate tax upon death. The equity in your home, of course, your bank and brokerage accounts, your business. If you operate a business and you don't think of the business as being, an asset worth money, you think of it as, well, I earn money from it. But that business gets valued and is subject to estate tax upon death. And of course, tangible personal property, like if you have a Picasso in your attic, like that's going to be taxed at your death. So, pay attention to those things when you're thinking about whether you have an estate tax issue. So what is estate tax? Estate tax is a tax on the privilege of transferring wealth to the next generation or, to another person other than your spouse. And this is your after-tax money, right? Because you've earned your money and you've paid income tax on it. And now you're asked to pay a second level of tax upon death before your assets can pass to your beneficiaries. So, even if you're a do-gooder who wants to help and pay tax, it is a double tax. So to the extent you can minimize that tax on money that you've already paid tax on, I'm all for it. And we talked about federal and we talked about Maryland estate tax. The feds have estate tax too. The federal exemption is much higher. It's $13.99 million right now. Next year, it's going to be 15 million. That was part of the big, beautiful bill. The estate tax exemption went up to 15 million, and then it will keep increasing with inflation. Maryland is at 5 million. It is not pegged to inflation. And in the last legislative session, it was proposed that the Maryland exemption go down to 2 million. So if the Maryland exemption goes down to 2 million, that's going to catch a lot of people who have equity in their homes and a life insurance policy are going to be subject to Maryland estate tax. So something to keep an eye on. That's why a lot of my clients are leaving Maryland and going to Florida or other tax-friendly jurisdictions. Now, the feds and Maryland allow you to share your estate tax exemption with your spouse. So you can, and this still says federal because Maryland, I haven't updated this slide since Maryland started to allow it too. So if you're married, you can actually give $10 million free of estate tax to the next generation or to whomever you want. And for federal purposes, next year, that would be 30 million. So estate tax becomes less of a problem. You just have to think about how this affects the basis of in your assets. Like what is the trade-off of income tax versus estate tax? I'm not going to get into the nitty-gritty about how we balance the two taxes, but it's something that we're always keeping in mind as estate planners. When you give your assets just outright to your spouse upon death, it's easy to do. You don't have to think about it. You might own things jointly and it'll all go to your spouse. But remember, that doesn't protect your children or other beneficiaries in case your spouse gets remarried, or in case your spouse gets sued after your death. So a lot of times we will not have joint ownership and have everything go to the spouse. We'll have everything go to a marital trust for the spouse's benefit that the spouse can benefit from. But if they remarry, that money in the marital trust is going back to your kids from your original marriage. It's not going to end up with the new spouse or the stepkids. And I can't tell you how many of my clients, when I tell them about this, are like, yes, give me a marital trust. So the downside to just letting everything be joint and share the exemption is that you lose out on some of these other protections. Okay, so like I said before, wills are not just for older people. When people first get married and have children, it's really important that they have a will because that's where they appoint guardians of their minor children in case both parents were to die while the child is under 18. Who's going to take care of that child? Doesn't matter how much money you have, it's really important to designate that person to take care of your children. My kids have all outgrown that, but I used to have my mom on there and I told my kids that and they're like, you were going to give us to Grandma Lane? So, and also regardless of age, everyone needs powers of attorney and living wills, and we'll talk about those. So there are two types of powers of attorney. The first type is a financial power of attorney. That is a document for while you're alive. It's not an after-death document, it's a lifetime document. And it appoints someone to pay your bills, manage your accounts, all of those things, if you can't do so yourself. And actually in Maryland, the way that the law works and the Maryland statutory power of attorney works is it actually takes effect immediately upon signing, because we found that banks were not honoring powers of attorney that said they took effect upon disability. The bank would say, well, I want to see this person in here. I don't believe that they're actually disabled, and it was difficult to prove. And that's why Maryland has gone the route of you sign it, it's in effect, so you might not want to give it out to so that they can't use it, the person you've appointed, but you should at least have a document in your lawyer's hands or in a safe that someone can get into in your house in case you can no longer make financial decisions for yourself. So those are important documents to have. The second is an advance directive. That is a combination of two things: appointing someone to make healthcare decisions for you. So this isn't financial, this is healthcare. Healthcare decisions for you if you can't make those decisions yourself, and also expressing what your wishes are in terms of end of life decision making. Do you want to be kept alive by artificial life support? Would you want a feeding tube or not? Would you want that withheld? And we do advanced directives, but Paula shared copies of this document called the 5 Wishes, which is essentially an advanced directive that goes through sort of 5 important things to consider. Who's going to make healthcare decisions for you when you can't make them yourself? What kind of life support or medical treatment do you want or do you not want? How comfortable do you want to be kept, even if it prolongs or shortens your life? How you want to be treated, and what you want your loved ones to know once you can no longer communicate it. So this is like a very compassionate document. It's really user friendly, so feel free to come and take a copy of it at the end. I'll leave them right here. Okay, this is one of my favorites. People, I'll sometimes have difficult clients or prospective clients, and they say, I just don't want to pay you. I can get a will off the internet. It's perfectly fine. Or they'll say, like, my brother-in-law, like, he's a personal injury lawyer. He's a lawyer. He's going to draft my will. It'll be totally fine. But law is like medicine. It's like you don't want to go to your cardiologist if you have a problem with your stomach. You want to go to like a GI specialist. And the law is very specialized because there's so much complexity tax-wise and state law-wise in wills, in inheritance, in probate, that you want to make sure that you work with someone who does that kind of work every day. The internet programs, they don't do a good job with like the state specific, like how things work in Maryland versus in DC versus in Virginia. And when clients come to see me, I ask them a lot of annoying questions. Like I feel like that sometimes I feel like that boy, Macaulay Culkin in that movie Home Alone, where he's like asking one question after another, and he's like, I'm a kid, I can't help it. And I'm like, I'm an estate planning lawyer, I can't help it. Like I have to ask these questions, all these permutations. Well, okay, well, what happens if your brother dies before you? Okay, it'll go to your other brother. Well, he's the same age as you. Like, should we have a third, like a tertiary beneficiary? A lot of questions just aren't asked in these sort of online programs. A lot of people come to me and they've been like watching Susie Orman, who's a really big fan of revocable living trusts. Revocable living trusts are like wills. They're a will substitute. A will, anything that's in your name upon your death, owned by you, no beneficiary, can follow your will. But in order to have your will enacted, your assets have to go through probate. Probate is a court-supervised process whereby your assets in your name are transferred to the beneficiaries under your will. There's nothing wrong with that process. I'm glad we have that process, because in countries where there are not like stable court-supervised transfers of property, then your property can become worthless. Like, there's a lot of instability when you don't have good property transfer systems. And we have very good property transfer systems in this country. It's just that, if you think ahead, you can avoid that court supervised process and still let things pass to your children in an organized fashion outside of the probate process. So if you have a bank account in your own name at your death, it's going to go through probate. If you have a bank account titled in the name of your revocable trust, it's yours for the rest of your life, but upon your death, it's going to pass to whoever you name in that trust without a court process involved at all. It just happens automatically. Now, you can also have it happen automatically by having a beneficiary on your mutual fund account. And that works well if you have a situation where, let's say you have your your adult child and you trust that child and you're not worried about divorce or that person having creditors, you don't need a trust. You can just have the beneficiary. If you need to protect things for a minor or for someone who might get in trouble or not be able to manage money, and you still want to avoid probate, then the best way to do that, I think, is through a revocable trust. Go ahead. Yes. So spendthrift, what a spendthrift provision is, and it took me a long time to realize this practicing law, but a spendthrift provision says that the trustee, the person in charge of the trust, can only put money in the hands of the beneficiary. If a creditor is knocking on the door, they cannot give the money to the creditor. They have to give it to the beneficiary. But that doesn't mean the creditor can't turn around and sue the beneficiary the next day. So I don't find like sort of the standard spendthrift provisions to be very effective to really protect money. You want to have a trust where you have drafted, or your lawyer has drafted their own provisions to say, okay, my son can get money for his health, maintenance, and support, or he gets X number of dollars a year, or it's in the full discretion of the trustee. That way, not only does the creditor not have their hands out to the trustee to take money upon your death, they can't even get money from your son because his money is protected long-term in a trust. Yep. Exactly. And that's why you want it in like a long-term protected trust. That the most highly creditor protected trusts really are something called sole and absolute discretion of the trustee. Like they are purely discretionary trusts. Those are very hard for creditors and divorcing spouses and even the beneficiaries themselves to get at, because there's no hook for a creditor to hang their hat on. It doesn't even say you get all the income. It says discretion of the trustee. So divorcing spouse goes to the trustee and says, well, you know, I'm the spouse divorcing, I get this money. And the trustee says, I don't even have to give that money to your husband. So I'm certainly not going to give it to you, divorcing spouse. Yep. You can have a corporate trustee. And corporate trustees are, I mean, some of them are expensive, some are not expensive. The downside to corporate trustees is they can be very slow at making decisions and difficult to deal with. Not so much of a problem if you just have like marketable securities. If you have anything odd, like a mineral interest, like I'm having trouble with Charles Schwab right now as a trustee because they don't want to deal with an asset in the trust that's like a mineral interest in Texas. And so, you know, they've kind of held everything up. But if it's a standard asset mix, then it should be okay. You can also have a friend, a family member, an accountant, a lawyer. You can choose any number of people to be trustee. So here we are at a charitable organization, HopeWell, that has, you know, really benefited all of us here in one way or another. And there, I always like to talk about ways that you can give to charity upon death that are really effective. Because I find that the charitable organizations that have a really strong planned giving program are really, and when I say planned giving, I mean people giving large gifts during lifetime or in their wills and trusts upon death, or in other ways, are really the most healthy, long-term, sustainable organizations. And you don't have to have a fancy trust to give to charity upon death. The best way to give to charity upon death is to make the charity the beneficiary of a portion or all of your IRA or 401k or 403b. And that's because those pre-tax assets are not great for individuals to inherit. Like when I put my kids as beneficiaries of my 401k at work, after I die, when they take the money out, they're going to have to pay almost 50% in income tax on that money because it was my pre-tax money, and then they're going to have to pay tax on it when they take it out. Whereas if I put HopeWell as my beneficiary, they get dollar for dollar the whole amount. There's no haircut for taxes. So rather than put HopeWell in your will, make them a beneficiary of your retirement account. You don't have to make them the whole beneficiary of the whole thing, but you could do a percentage. And that makes the whole pie, your whole estate asset pie, bigger because you're cutting out a piece from the government and you're giving it directly to charity. And I just love that technique because you don't have to come to me. You don't have to pay a lawyer to do it. You just fill out your beneficiary designation form. That's all I've got prepared, but I love answering questions. So go ahead. Mm-hmm. Well, it used to be that they could do prorated over their life expectancy, which was great. That law changed in the last few years. Now they have 10 years to take it out, and they have to take 10% a year. And they pay the tax at their rate, which might be lower than your rate. So it's not as bad as you paying the tax on it, but it's still, if you're going to benefit charity, that's where it should come from, not out of the will or trust. Go ahead.
Vote slip that's deeded to me. I have all kinds of things. I have a will,
Mm-hmm.
which I have. As my beneficiaries, as I mentioned before, are getting older, I'm thinking of changing everything over to my stepson. He's on his second marriage.
Yeah.
You know,
What
do I want beneficiaries? Do I want to trust? I mean, that kind of confused between trust and benefit.
Well, you want beneficiaries on your pre-tax money, like your 401k or IRA. Definitely want beneficiaries there and not a trust, because the income tax rates of trusts are higher. And if you don't have a beneficiary, there'll be all the tax in your estate. Now, if all of these assets are just in your name, then you're the perfect candidate for a revocable trust that would own everything during lifetime, your house, your boat slip, your accounts that are not retirement accounts. And then within that revocable trust, you would say, I leave X amount to my stepson in a trust that's managed by, whoever you appoint, in a way that is protected in case he gets divorced again or in a car accident and sued. But yeah, that would be a really, I think, good plan for that situation. Sure. Go ahead. Yes, the beneficiary, do you mean the trustee or the beneficiary? Yes. So a lot of times people want to create trusts for beneficiaries who they actually have a lot of faith in. They want their beneficiary to be able to manage their own money, but still have it in the trust wrapper to protect from like lawsuit creditors or divorce. So under Maryland law, you can have a trust and let the beneficiary be his or her own trustee. And as long as it has certain provisions like health, education, maintenance, and support, it is still creditor protected. And it's not taxed at their death. So that's one of my favorite techniques to use when you trust someone, but you don't necessarily trust the third parties out there who might go after them. Sure. You can have your beneficiary be his or her own trustee, because if you trust the way they manage money and you don't think they're just going to take all the money out and blow it on something, they can be their own trustee and the money is protected in case they get divorced or someone sues them. But they don't have to go to another person for money because it's in this trust wrapper.
Trust is for blind. You can't see someone.
Right. A trust. Yeah. No, if they're their own trustee, they'll know. But if it's, the only person who's going to know how much is in the trust, is going to be the trustee. In Maryland, beneficiaries have rights to information, so they can find out, but like a creditor can't find out. It doesn't become part of the public record in probate. Like if you go through probate, all your assets are listed and everyone can look at them and say, oh, I didn't know he had that much money. Whereas a revocable trust creates privacy. Go ahead. Good question. So you can have as many trusts as you want. Typically with revocable trusts in a state like Maryland, like each spouse would have his or her own trust. Joint trusts don't work. Joint trusts work really well, like out west in community property states. They don't work as well here upon the death of the first spouse. And if you wanted to have like irrevocable trusts, you can create as many as you want. In terms of the reports, annual reports, let's say, a beneficiary in Maryland can request at any time, once a year actually, an accounting of what's going on in the trust. So all of the, what came into the trust, what came out of the trust. You can waive that. When you draft your document, you can say, look, I don't want there to have to be accountings, but a beneficiary can always request one.
So if I wanted to donate, say, $50,000, I can create a trust for that $50,000.
Yes, but I don't know if it's worth it to create a trust for $50,000. Yeah, definitely. Then you leave it to them in a trust. You appoint someone as the trustee, or you let them be their own trustee. But yeah, and that trust can be created under your own will or under your own revocable trust. You don't have to create it now. Like you don't have to have the trust, sitting there active and filing tax returns now. It can spring into action upon death. Mm-hmm. Yes. So a special needs trust, if you have a relative who you think is or could be on SSDI, any kind of public benefits, you can leave them money, or you really should only leave them money in a special needs trust, which is a trust that's designed to not disqualify them from any benefits they are already receiving or may receive in the future. And you can create that in your will or revocable trust, or you can create a separate standalone trust now, which sometimes, like let's say you have a niece or nephew who is special needs, and you and your siblings all want to leave money to this niece or nephew, then just create one special needs trust now, and everyone can leave money to it upon their death or during their lifetime. Well, it can be anyone you want. So it could be a relative of yours, a friend, a lawyer, a bank. You choose. Just should be someone who's sophisticated enough to follow the rules of the trust and make sure they're not disqualifying the beneficiary. Yes, as long as it's its own trust, it's not something that only comes into action at your sister's death. If it's an existing trust, then you can leave money to it in your will. Right, because you don't know, because if you die before her, there won't be a trust there to receive it. Yeah. Go ahead. Oh, you should. You should. I mean, you should have successor and successors to successors. Yeah. And successors could be descendants of your son if he has descendants in the future, And then if he doesn't, it could be your sister, or it could be a charity. Okay. Go ahead.
Scenario. End up having to be in a nursing home for a long time. And we don't have, we don't have death with dignity in this state.
Yeah.
But, and all your assets drain to the, you want to leave something to, but then you can't get any of it.
Yeah, I mean, you can create like a trust. You can give away assets during your lifetime. Like there's a 5-year look back period, but even if you give away assets right before you go into the nursing home, that you still, some of it still is protected. It's like proportional. And I'm not a Medicaid planning attorney, so I'm not an expert in this area, but you can create trusts and put money in them now. And as long as, the more is protected, the longer it is before you go into a nursing home, from the time that you make the gift into that trust. But you really are parting with that money, and you really will have to go on Medicaid. So you have to have faith that Medicaid's going to be around, and you have to have faith, you have to be comfortable that that's where, that you want to be on Medicaid, that you're comfortable. It might be that you earned your money and you want to spend that money so you can get the best care you can get. So, not Medicaid is not for everyone. You might want to spend down your money so that you can have a better quality of life. So it's not, I like my clients to think about themselves first before the next generation. You should have your money to take care of you if you want it to, rather than give it away.
Whatever's in that trust
It won't be forced to be spent down. Right, exactly. Yep. Yep. Go ahead. Well, a lot of anything like you specifically mentioned in your will has to be separately appraised and go through the probate process. Even if it's in your trust, if there's a taxable estate, it has to be separately appraised. I often say that if there is not a lot of controversy, like people will, if you believe that your family will respect your wishes, it's okay to do it in an informal memo. And then you just have a general bequest in your documents that says, to the extent I haven't specifically mentioned this in my memo, then it can all go to my daughter. That's how we but if you think people are going to sue each other over this property, then it's better to have it written out in the legal document. Any other questions? Yep.
My sister finally did a will the last month or so, and
Not on the deed. If they wanted to pass to their daughter sort of outside of the probate process and they don't have a revocable trust, they want to do something called a life estate deed, where it says the house belongs to the two of them for the rest of their lives, and they can sell it and they can mortgage it. But if they die owning it, it goes to their daughter. And you can do that right in the deed. Life estate deed. It's a life estate deed with full power to sell. Go ahead. Yeah, a life estate deed with full power to sell. We just call it a life estate deed with powers. Anyone have any other questions? Yes.
I was lucky enough to give birth to a trust.
So a lot of times people get recommendations from friends, and that's often a good way to go. The way that we work at our firm is we have a process where, anyone who calls in has like a free initial call. We spend about 30 minutes on the phone getting an idea of what you need and, what we might recommend. And then we tell you what the cost will be. And we try to do this estate planning work on a flat fee basis so that from that first call, okay, this is what the cost is. And then you decide, do I want to move forward or do I not want to move forward? You get a feel for the lawyer you're talking to and whether you think you'll be a good match. And, sometimes people call us and they want, business advice or something we don't do. And that's where we can say, well, I wish we could help you, but we don't do that. But I love these calls because then when clients do come in to meet with us, there's no surprises. We don't have to talk about fees. Like that's all been discussed. Everyone knows. And then the rest of the client relationship is really positive. Go ahead. Okay. For that, we do like either by phone or Zoom for that for 30 minutes. Yeah, and then after that, we do the in-person meeting. But I don't know. I mean, if you have questions, I'm happy to talk to you in person afterwards. I can tell you what it's going to cost, and then you can come in person. Yeah. But that's typically our process. And I don't know how other firms work, but you should make sure that you talk to, who you're going to work with and decide and ask about fees and ask about process. We try to keep the process very organized where, from the, we have the initial call, then we have the meeting and we gather all the information and we draft the documents. And then we review the documents together, make any changes, and then, you come back in and sign. So it's a pretty smooth process. The phone call, it's really just a general idea, the questions that like, family situation, children, no children, are you giving to siblings, are you giving to charity? And then just general financial questions so that I can determine whether you have a taxable estate or not. Do we need to worry about estate tax planning? Do we need to draft a special needs trust, things like that. Then when we get to before the initial meeting, we send out a questionnaire where we really ask you about your specific assets, how they're titled, who the beneficiaries are, because that's what I want to uncover. Like I said, we can do really nice documents, but I want to make sure I know every asset you have, and I've given you instructions on how each one needs to be retitled or beneficiaries added. So you get that questionnaire, and that comes to us before the meeting. But there's not, if you have like existing family trusts or other things you want us to look at, those you can bring to the meeting. But that's about it. Yes. Yeah. Yeah, especially after someone passes away, we are working regularly with the accountants because we have to make sure that we're not doing anything that's going to negatively affect the income tax situation of the client. But first, the planning process, we don't typically have to work with the accountants that much unless your accountant is the one who keeps track of all of your assets, and it's easier for you to have your accountant send me your financial information. Yeah, and our firm, we have 11 lawyers, so it's not just me working there, and we have offices in Towson and Annapolis. Go ahead. Good question. No, the laws of your state, of your home state, like Maryland, if you're a Maryland resident, are going to govern all of the inheritance and until it gets to that person. So if you're leaving someone $1 million and they live in New York has its own estate tax. So sometimes if I know that your child lives in New York, we might want to leave things in a trust versus outright to them to protect from that New York layer of tax. But everything, that's at the second death, that's at the child's death. At your death, it's really all governed by your home state law. Oh, and one thing that is always good news, when someone inherits money, there's no income, unless it's an IRA, there's no income tax on it. So if you inherit $1 million, yeah, maybe there's a state tax that the estate has to pay, but you, the inheritor, you get that tax free. No, unless you give them like a 401k or an IRA, then they have to pay income tax when they take the money out. But aside from that, they get that money tax free. Yeah, you can change that either in your will or trust anytime you want.
So that
Right, they're young. So it, no, you don't want to put an adult on the accounts. You want it owned in your trust, and then your trust says, appoints who's going to be in charge for those kids until they're a certain age. Yeah. The only time you need an adult on an account is if you've like created a uniform transfers to minors account, like you've already given the money away during lifetime. That's different than if you're leaving it upon death. If you've already given it to them and it's in a uniform transfers to minors account, then you're right, you need a custodian, someone on the account. But if you're talking about your money that you're leaving upon death, then no, there's much more creative ways to do it. Go ahead. They'll never have to pay income tax, but you can give $19,000 per person. If you're married, you can give $38,000 per person per year, and you don't have to file a gift tax return, and they don't pay income tax on it. But let's say you want to give $1 million, you can do that. You can actually give $30 million because you can give the whole federal exemption away while you're living, but you have to file a gift tax return because that gift eats up a little bit of that 30 million you can pass free of tax at death. But that's only after you get above that 19,000, 38,000 per person limit that you have to do that. Well, thanks everyone. Really enjoyed talking to you.